Hello, this is Attorney Brian Pendergraft with the Pendergraft Firm LLC, and I'm an attorney that is licensed to practice law in both Maryland and the District of Columbia. And today I'm going over the Declaration of Compliance with Coronavirus Aid, Relief, and Economic Security Act form that is required to be filed with all new failure to pay rent cases here in Maryland between June 4th to August 24th. And that is the form that I have pulled up on the screen. So even if your property is not covered by the CARES Act, this form is still required to be filed with the case or it will be dismissed. And so that's why I just want to do a quick overview of this form. But a disclaimer, this is general information. This is not legal advice. So for legal advice, you can contact an attorney that is licensed to practice law in your jurisdiction. So the first part of the form, which I'm going to highlight here so you can see what I'm talking about. All right, there we go. So the first part of the form, what it does is it asks where the property is located, and it asks you to verify if how you investigated the property received a mortgage forbearance, or if it is a covered property under the CARES Act. So you see there's a number of different options, such as verifying that you use the Fannie Mae and the Freddie Mac lookup tool. That they have right here on the form, that they have links to it on the form. And those tools are an easy way to see if the mortgage is federally backed. And if it is federally backed, then it fits the qualification for a covered property in this covered property. So you see it has other ways to verify here, such as did you contacting the mortgage servicer directly. I think as a general rule, the more investigation you can show, the better, especially if the property is not a covered property under the CARES Act, because I believe that the landlord has the burden of proof of proving or showing that the property is not covered. So the second part of the form, I'm going to highlight this here so you can see what I'm talking about. That's what I mean by second part of the form. So what it does, it asks for 3 separate scenarios, and of course only one of these can be checked off. And the first scenario is if a mortgage forbearance was granted of a multifamily backed mortgage loan. So that is the first scenario, and then the second scenario is it asks if it is a covered property under the CARES Act. And the third scenario is if the property is not a covered property under the CARES Act, and if it has not received a mortgage forbearance. So I'm actually going to put another link in the description for another video of mine where I covered what a covered property is. I'm going to put that link in the description. So depending on your specific situation, you have to check off one of the 3, and there may be additional steps that need to be taken depending on which option you choose. For example, for landlords that have covered properties, they have to send tenants 30-day notices after July 25th and attach the notice to the complaint. Anyways, my main point of doing this video was to bring awareness that this form needs to be filed with failure to pay rent actions, so landlords don't end up messing up their cases too much and filing these cases without them. Also, this form is not required for other causes of action, such as tenant holding over a breach of lease actions. So yeah, that's it. So I know I wasn't answering any particular questions here, but I'll plug my Ask a Real Estate Attorney series. Anyway, if you have any questions that you would like to be considered for my Ask a Real Estate Attorney series, please just let me know in the comments. And if you want me to keep these videos coming, please like, comment, and subscribe. Thanks for watching.